So welcome back, dear students. Today we are going to start a new lecture on writ of certiorari. First of all, you must understand what is a writ of certiorari. This writ of certiorari is an order issued by the High Court or Supreme Court to an inferior court or body if he has acted illegally in order to adjudicate any matter. But this writ lies only to rectify the judicial decisions and to remove and adjudicate upon the validity of judicial acts only. The writ of certiorari can be issued to a judicial or quasi-judicial body on the following grounds. You see, there are three grounds on the basis of which a writ of certiorari may be allowed by the High Court or Supreme Court. Because you used to write the grounds of petition in your writ petition also. So these are the three grounds. Number one, want or excess of jurisdiction. This means that the lower court had no jurisdiction. They wanted the jurisdiction, or they had the jurisdiction but they exceeded the jurisdiction. So first ground for issue of certiorari writ is want or excess of jurisdiction. Then second ground which you can take up while drafting this writ is violation of procedure or disregard of natural justice. The procedure prescribed by law is not violated by the lower court, or the principles of natural justice like audi alter partem, here the other side also, other party was not heard and order was passed against him. So this is disregard of natural justice or violation of procedure prescribed by law. And the third ground for issue of certiorari writ is error of law apparent on the face of the record. The lower court or the lower authority has committed error of law, and that error of law is noticeable, visible, apparent on the face of record. If you read the order of the lower court, then error of law is very much apparent there. So these are the three grounds for issue of writ of certiorari. I will repeat because you are supposed to draft the grounds of petition in your writ. So you must know what are those grounds. So the ground number one is want of jurisdiction with the lower court or excess of jurisdiction with the lower court. Second ground is violation of procedure. The procedure which is prescribed by law is not followed by the lower court, or they have disregarded the principles of natural justice. And the third major ground is that there is an error of law which is apparent and noticeable, clearly visible on the face of the record. So dear students, in nutshell, this is the meaning of a writ of certiorari. This writ of certiorari, as I told you earlier also, is a supervisory jurisdiction, and the court is not entitled to act as appellate court. It can be issued against a subordinate court by the High Court or Supreme Court, as the case may be. High Court will issue writ of certiorari exercising its jurisdiction under Article 226, and Supreme Court may issue writ of certiorari while exercising its writ jurisdiction under Article 32 of Constitution of India. Now I'll give you few illustrations of certiorari as to what is actual meaning of certiorari. The first leading case is Province of Bombay versus Khushal Das. This case was decided way back in 1950 by the Supreme Court. It was held in this case that whenever any body of persons having legal authority to determine questions affecting rights of subjects and having duty to act judicially acts in excess of their legal authority, a writ of certiorari lies. Whenever the lower court, whenever the legal authority acts in excess of their jurisdiction, excess of their authority, then writ of certiorari lies. Suppose a civil judge junior division has decided a case whose valuation was 1 crore. This case should have been decided by civil judge senior division, but it was decided by civil judge junior division. So Supreme Court and High Court can quash the judgment passed by the Civil Judge Junior Division because he has acted in excess of his legal authority. Then second illustration relates to the leading case of Maneka Gandhi versus Union of India. This case was decided by the Supreme Court way back in 1978. In this case, the passport of Mrs. Maneka Gandhi was impounded without giving her opportunity of hearing. So the principle of natural justice or the alter partem was violated. This order was quashed in a writ of certiorari by the Supreme Court because of violation of principles of natural justice, that is, audi alter partem. Here the other side also. You can impound her passport after giving her due right of hearing. But without appearance of Mrs. Maneka Gandhi, you have impounded her passport ex parte without hearing her. So writ of certiorari will lie because the passport authority has violated the principles of natural justice. Now, dear students, with this background in mind, we will start drafting of a writ of certiorari. First of all, you are supposed to select the name of the court. If the matter relates to Noida, then obviously you will file your writ of certiorari either in the Allahabad High Court, and if you want to go straight to the Supreme Court, then you will go to the Supreme Court. But since you have selected the High Court first, you want to go to the High Court first. So you will have to select the name of the court like this. You will have to draft the name of the court in the Honorable High Court of Judicature at Allahabad. And then in the bracket, you will write down original civil jurisdiction. Dear students, this jurisdiction of writ is not appellate. It is original civil jurisdiction relating to 5 categories of writs. Then you will draft writ petition number dash dash of the year in which the writ is to be filed. So writ petition number dash dash of 2019. 2019 is a year in which this petition was filed before the Allahabad High Court. And you have not mentioned writ number here. Because you do not know the writ number, you are drafting this writ while sitting in your corporate office. You will be allotted writ number by the staff of the court, or if it is a case of e-filing, then computerized writ petition number will be allotted to you. But at the time of drafting, you are not aware about the writ petition number. So you will draft it like this, that writ petition number dash dash of 2019. Then the complete name, parentage, and address of the petitioner is to be written, is to be drafted by you. Like A, son of B, resident of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar. He is our petitioner. Now this case is being filed, this writ is being filed against whom? Versus number 1, State of UP. State of UP is the first respondent. Then number 2, Drug Controller, District Gautam Buddha Nagar, UP is our respondent number 2. And then third respondent is Appellate Tribunal, Drug Controller, Lucknow, UP. So we have 3 respondents in this writ petition. Now let us see what are the facts of this case. After writing the complete name, parentage, address of the petitioner and respondents, now center heading will come petition under Article 226 of the Constitution for the issue of a writ of certiorari. If you are going to file this petition in the Supreme Court, then the center heading would be petition under Article 32 of the Constitution for the issue of a writ of certiorari. Now, to whom you are addressing this petition? You will draft it like this too. Honorable the Chief Justice, to Honorable the Chief Justice and all his companion judges of the Honorable High Court of Judicature at Allahabad. Why you are addressing to the full court? You are addressing this writ of certiorari to Honorable the Chief Justice and all his companion judges of the Honorable High Court of Judicature at Allahabad. Why? Because you do not know before which judge your petition is going to be listed for hearing. So you are addressing Honorable the Chief Justice and all his companion judges of the Honorable High Court of Judicature at Allahabad. Now, the actual drafting and actual facts drafting comes after this line. Next para you will write down. The above named petitioner most respectfully submits as under. Now, what is your submission? Now you will draft all the facts one by one in different paragraphs, and all these paragraphs are to be numbered serially, consecutively 1, 2, 3, 4, 5, 6, like this. So, para number 1, that the petitioner is a stockist and dealer in drugs and carries on his business in the name and style of Apollo Pharmacy at shop number 11 in sector 107 Market, Noida, district Gautam Buddha Nagar, UP. So our petitioner is a stockist in drugs and his name and style of the business is Apollo Pharmacy. Para 2, that the petitioner held a drug dealer's license number 4598 dated 1/1/2010 and has been carrying on his business for the last 9 years. See, this petition is being filed in 2019. The petitioner is having a drug dealer's license since 1/1/2010. So he is doing this business for the last 9 years. Para 3, that on 1/1/2019, the petitioner received a notice from respondent number 2 to show cause why his license should not be cancelled for selling substandard and spurious drugs. He was also required by the notice to produce his license before respondent number 2. So this is the bundle of facts giving rise to cause of action to the petitioner, that he has received a notice from respondent number 2 in which he is asked to show cause as to why his license should not be cancelled for selling substandard and spurious drugs. And in the notice it was also mentioned that petitioner was required to produce his license before respondent number 2. Then para number 4, on 7th January 2019, the petitioner submitted his explanation to the show cause notice, submitting that he did not sell any substandard or spurious drugs and that he sells only drugs in their original containers obtained from reputed drug manufacturers. He expressed his inability to produce the license as the same had been submitted to the civil surgeon Gautam Buddha Nagar, UP for renewal. However, a photocopy of the license was submitted along with the reply. So this is the reply of the petitioner, that he is submitting his explanation to the show cause notice that he never sold any substandard or spurious drugs and he sells only drugs in their original packing as received from the drug manufacturers. And why he could not produce his license, he has explained it, and he expressed his inability to produce the license as the same had been submitted to the civil surgeon Gautam Buddha Nagar, UP for renewal. But the petitioner submitted a photocopy of the license along with this reply. Para 5, how to draft it further, that without giving proper consideration to the pleas raised by the petitioner, the respondent number 2 passed an order dated 15th March 2019, cancelling the petitioner's license, saying that the petitioner has failed to produce his license and he did not rely on the photocopy of the license submitted by the petitioner. Dear students, when original license is submitted in the office of civil surgeon for renewal, the petitioner cannot produce his original license again before this authority. Obviously, he will file photocopy of the license, but the authorities have not relied upon the photocopy, and they have not seen the explanation also that the original license has been submitted in the office of civil surgeon Noida, Gautam Buddha Nagar. Para 6, that the petitioner preferred an appeal against the order of respondent number 2 to respondent number 3. When drug inspector did not hear the pleas of the petitioner, then petitioner preferred an appeal against the order of drug controller to the respondent number 3, that is the tribunal situated at Lucknow. Para 6, that by order dated 16 May 2019, respondent number 3 dismissed the appeal of the petitioner in a mechanical manner without giving any opportunity of hearing to the petitioner. See, this is again violation of principles of natural justice, that while passing order dated 16 May 2019, respondent number 3, tribunal, dismissed the appeal of the petitioner in a mechanical manner and no opportunity of hearing was given by the tribunal also. Para number 8, this is a compulsory paragraph, that the petitioner has no other remedy but to approach this honorable court for effective relief. Para 9, that the orders passed by the respondent number 2 and 3 are void and illegal for the following grounds, amongst others. Now you are to draft the grounds of the petition. These were the facts, bundle of facts giving rise to cause of action. You explained how you submitted your reply before the drug controller. He did not paid heed to your pleas, passed an order cancelling your license. Then you have filed appeal before the tribunal. Again, you were not heard, and the order of the appellate authority is also void and illegal. Why? Because the principles of natural justice, audi alter partem, here the other side also was not followed. Now the grounds of writ of certiorari. First ground is because the orders of respondent number 2 and 3 are illegal, void, and vitiated, as they have acted in violation of principles of natural justice, inasmuch as no opportunity of hearing was given to the petitioner. This is the main reason that the principle of natural justice was not followed, because no opportunity of hearing was given to the petitioner either by respondent number 2 or by respondent number 3. Second ground is because both the respondents number 2 and 3 have placed great reliance on the report of Central Drug Laboratory dated 10th March 2019, which was never disclosed to the petitioner, and the petitioner was not given any opportunity to meet and reply the said report. See, the license of the petitioner was cancelled on the basis of report of Central Drug Laboratory report dated 10th March 2019. Law demands, natural justice demands that you give this copy of the report to the petitioner, then he will challenge this report also. But the copy of this report was never given to the petitioner, and he was not given any opportunity to meet and reply the said report. Third ground, because the authorities have been influenced by the failure of the petitioner to produce the license, but have themselves failed to consider the petitioner's explanation that the license had been submitted to civil surgeon for renewal. See, this ground is very important. The tribunal as well as the drug controller, they are influenced by the factum of non-production of the license by the petitioner. But they have not seen the explanation as to why petitioner could not produce his license before the drug controller or before the tribunal. The reason was that petitioner had already submitted his license to civil surgeon Noida for renewal. And as dear students, you know the law of evidence, that if the original is in possession of opposite party, then you have a right to file secondary evidence in the shape of photocopy. So photocopy can be filed when original is in the possession of the department. Then fourth round, because respondent number 2 and 3 have not applied their minds to the facts and circumstances of the case. They have failed to appreciate the value of the photocopy of the license when its original was submitted in the office of civil surgeon Gautam Buddha Nagar, UP. Fifth round, because the impugned order violates the fundamental right of the petitioner to carry on his trade and business as guaranteed by Article 19(1)(g) of Constitution of India. You will have to show which of your legal right is violated or which one of your fundamental right is violated. So here the petitioner pleads that the impugned orders passed by the drug controller as well as by the tribunal at Lucknow, the impugned orders violated the fundamental right of the petitioner. And what is the fundamental right? Right to carry on his trade, profession or business as guaranteed by Article 19(1)(g) of the Constitution of India. Trade, profession and business. This is my fundamental right as petitioner, guaranteed to me by Article 19(1)(g) of Constitution of India. Then next is a prayer. On these grounds, on these bundle of facts, the petitioner says, it is therefore most respectfully prayed, A, the first relief which you want from the Allahabad High Court is that a writ, direction or order in the nature of certiorari be issued, quashing the order of respondent number 2, that is the drug controller order dated 15th March 2019, and the order of respondent number 3, tribunal, appellate tribunal at Lucknow, order dated 16th May 2019. So you want that these two orders should be quashed under writ of certiorari. Yes, you have rightly drafted this relief, and we relieve that any other order which this honorable court thinks fit in the circumstances of the case may also be passed in the interest of justice. So this is your chief prayer, that the orders passed by the respondent number 2, the drug controller, and order passed by the appellate tribunal at Lucknow, both the orders should be quashed. And second relief is customary to write down that any other order which this honorable court thinks fit in the circumstances of the case may also be passed in the interest of justice. Then at last, you are supposed to draft you are supposed to obtain the signature of the petitioner on this petition. Date of filing this petition will be mentioned by you. And before the date, you will mention the place also where you have signed this petition. So your place is, say, Noida, or it may be Allahabad also. Your writ may be drafted at Allahabad also, because you have engaged a lawyer at Allahabad. And date is 1st June 2019. And dear students, because this writ of certiorari is drafted by ABC advocate, he is counsel for the petitioner. So you are supposed to draft his name also, and you will write down, you will draft it like this, through counsel ABC advocate. And then the signature of ABC advocate are also required on this petition before filing. So this is how, dear students, we have learned the drafting of a writ of certiorari, and I told you that there are 3 grounds for issue of a writ of certiorari, and majorly this writ is issued by the High Court or by the Supreme Court to quash the orders of the lower authority or the lower court if they have no jurisdiction to pass the order, there was want of jurisdiction, or if jurisdiction was there but they have exceeded their jurisdiction, they have violated the procedure established by law, or the lower courts have not followed the principles of natural justice, that is right of hearing to be given to opposite party. And then third ground I told you was and is that any error of law which is very much visible, clear, apparent on the face of record. That means whenever you read the order passed by the lower court, the error of law is reflected in the judgment itself. So on these three grounds, a writ of certiorari may be issued by the High Court or by the Supreme Court.